I'm going to try to keep us a little bit on track here today. And we're going to go into our next panel now. Before we do, one of the things we're doing in between the sessions is this is a big year, as I mentioned, on a number of different privacy fronts. I think we've all seen how much generative AI is starting to affect all of our companies. And we have a really outstanding panel later today from the European side on generative AI. But it's also one of the first years in a long time that we've seen a lot of movement on potential federal healthcare, federal privacy legislation. And we also have now 5, maybe 6 new state law going into effect. One of the things that we've seen on our side here at Wirewell, and I'm going to speak about myself personally, is we've been, and I have been quite supportive of a national privacy law for years. We've been writing about the subject and why it's necessary. So in many ways, I think any version of what's been going on the Hill, I think would be a huge movement forward for privacy enforcement across the country. There are very sticky issues, obviously, we've seen coming up, including on preemption of what's going on in the states, that I think still have to be worked out. But one of the things, aside from the federal privacy law, we've seen over the last 4 or 5 years, just helping companies across the world, is in addition to what's being considered in the federal privacy law, we've noticed some really interesting issues that state legislatures and enforcement authorities and federal and international authorities should just think about outside of what's being considered. And one of the main challenges I've seen personally in the privacy world when it comes to privacy impact assessments and data protection impact assessments is there is currently no standard output of what a data privacy impact assessment or a privacy impact assessment or a high-risk impact assessment or a data transfer impact assessment or any of the other privacy impact assessments should look like anywhere in the world. And it's one of the strangest, personally, things I have ever seen, because as a result of having complete discretion at every company to implement your own version of a privacy impact assessment, and because there's no definitional output that any country regulator or any state regulator or any federal regulator allows, virtually every company, every consulting firm, every law firm, every lawyer within the law firm, every privacy consultant within a practice, and even within a company does it completely differently. And the result is it's really hard to enforce anything. I mean, there's no standard version of what it should look like, what you should record, whether they've assessed it the right way. And I analogize it to, imagine instead of filing a standard tax return here in the United States, imagine you just could generally declare what your income would be under some personal analysis and how much taxes you had to be, and you had to document it into some document. And it makes it basically impossible to know exactly what you should do. It makes it impossible to have a standard conversation with a regulator anywhere in Europe or in the United States about what the standard should be. And to be honest, I think it makes it basically impossible to enforce whether anybody has done it differently or correctly, or to audit whether it has been done differently or correctly. So I do think there's an opportunity coming up in California and in Colorado where they're trying to define exactly what should be filed, in terms of your actual filing. I hope the regulators in California, Colorado, and the states actually take a look at this, because if there were one standard way to do it, I think it would make a lot of lives a lot easier. So one observation, we'll bring a couple of these up as we go through the day. And now we're going to transition to our next panel. In my view, one of the most important enforcement matters that have come out of the federal government in several years is the healthcare enforcement cases coming out of the FTC and parallel guidance coming from HHS around the sharing of ad tech and healthcare personal data through ad technology like pixels. And recently, the FTC announced two enforcement decisions, one involving GoodRx and one involving BetterHelp. And HHS, Office of Civil Rights, by the way, I may have it, I hope I get this right, issued a bulletin around the sharing of healthcare, data via pixels and healthcare technology areas. And we have two fantastic speakers to talk about some of these issues here today. From the Department of Health and Human Services, Lisa Goldstein, who's an information privacy specialist, who will be talking about a number of issues coming out of HHS. And Ronnie Solomon, an attorney with the Federal Trade Commission, who's going to be talking about some of the matters coming out of the FTC. So please join me in welcoming him, and we'll be talking about these two important cases. Well, Ronnie and Lisa, again, thank you very much for joining us here today. And these are really, really important things coming up from both HHS and FTC. So we want to spend a fair amount of time talking about them. But one of the things we do as part of all of our spokes community sessions is we give our folks a moment to just introduce yourselves and talk about your background and how you got to working in the government or into your position. So if I may, could I turn it over to you first, Lisa, to talk a little bit about your background and your role at HHS?
Sure. Thanks so much for having me here today. As you mentioned, my title is actually gotten a little longer lately. It is the Health Information Privacy Data and Cybersecurity Policy Specialist. I've been with OCR for about little over 2.5 years now. And before coming to OCR, I worked at associations for and on behalf of healthcare providers for about 15 years. I am an attorney, so I was in law school before that. And actually, coincidentally, while I was in law school, I did participate in the federal legislation clinic there, where my client was very interested in healthcare privacy. And so my project was involved looking at the 2002 modifications to the HIPAA privacy rule, which was actually just as they were going into effect, just not long after they'd come out. And there was a lot of what I did actually was spend time developing side-by-sides of all the different legislation that was being introduced in Congress about different privacy legislation, healthcare privacy legislation at that time. Anyway, so that was back in the day. And so while I was in the associations, I worked on a wide variety of issues, learning about healthcare providers and how they work. And now at OCR, I focus on developing policy related to the HIPAA privacy rule, the security rule, the enforcement rule, and the breach notification rule. So those, when we talk about the HIPAA rules, that's what we're talking about. And my specific focus is on issues at the intersection between the HIPAA rules and health IT.
Awesome. And how long, do you mind just giving 1 or 2 moments on the HHS Office of Civil Rights?
Sure. It's a good question. So at the Office for Civil Rights, we investigate complaints, we enforce rights, develop policy and regulations, and provide technical assistance and public education to ensure an understanding of and compliance with federal non-discrimination laws, as well as health information privacy. So it is the Office for Civil Rights, but we do have it's focused on healthcare, civil rights in the healthcare environment, which includes health information privacy.
Lisa, thanks so much. We're looking forward to the discussion here today. And Ronnie, do you mind giving a little bit on your background?
Sure. It's a pleasure being here today. Nice to see everyone, and thank you to Wirewheel for hosting this conference. My name is Ronnie Solomon. I'm an attorney at the Federal Trade Commission. I've been there for about 6 years, and prior to that, I worked in private practice at Fenwick and West in San Francisco, where I was in the litigation group and represented mostly tech companies and private litigation. At the FTC, my work focuses on litigation, investigations, and policy, kind of a mix of all three. And I'm in the privacy division, so my cases are all privacy and data security related. As I mentioned, I originally started in private practice and always had an interest in public service. So after a few years of kind of being on the other side, wanted to make a switch to working for the government and enforcing our laws. So that's what I did.
And do you mind giving just a moment of background on the FTC's privacy, enforcement area? And for example, are there different folks focused on different verticals, or for example, healthcare or otherwise, or is it more of a general privacy enforcement group?
Yeah. So to first answer your question, it is a general privacy division. The FTC, we are an enforcement agency, so we're not really a regulator. Most of our work focuses on enforcing the law. The FTC, as you all probably know, there is no baseline national privacy law, as there are in the States or in Europe. And so we enforce privacy and data security law through our prohibition on unfair and deceptive business practices. So for example, when a company deceives consumers about how they use their data, that could be the basis for a violation of our law. If a company fails to implement reasonable data security measures, for example, that could be an unfair practice and a basis for a violation of our law. We do a lot of other stuff besides privacy. We have a whole division dedicated to reviewing mergers, anti-competitive practices, in addition to, on the consumer protection side, privacy, ad practices, fraud, the whole gamut. So we're generally dedicated to protecting consumers of this country.
Ronnie, thanks so much. And so we're really looking forward to the discussion today. And for those of you here or watching, obviously both Ronnie and Lisa are currently serving in the government. And that means, of course, that there are limitations on what they can talk about and how they can comment on things. So we're going to have to be patient about that. Please feel free to ask questions. Sometimes our panelists will be able to answer, and sometimes they won't, or they'll be able to answer in a certain way. So we'll all respect that as we go through things today. And of course, there are investigations going on in your departments, which make it tough for you to comment in specific ways. So, Ronnie, if you don't mind, I'm going to start with you on some of the recent announcements and enforcement actions. I mentioned the GoodRx enforcement action in my opening, involving the sharing of sensitive health information with third-party companies. And the FTC's enforcement action announced in February against GoodRx is significant, and it really did break new ground. Among other things, it's the first time that the FTC has brought an enforcement action under the health breach notification rule with civil penalties. And it also alleges a number of deceptive and unfair practices relating to disclosing sensitive healthcare data. So could you talk a little bit about the FTC's allegations in that case and what kind of information was actually shared by GoodRx?
Yeah, sure. Happy to. So I'm the attorney that actually led that matter for the FTC. So GoodRx, many of you may know, they are a online platform, mobile app that allows consumers to search for discounts on prescription drugs. They also offer a telehealth platform. What we alleged was that GoodRx was, through the use of certain pixels and SDKs, was sharing information with third parties. The complaint names Google and Facebook, for example, and sharing really sensitive information that was personally identifiable. So things like the names of medications that people had searched for, or in some cases actually redeemed at the pharmacy, the names of health conditions that people were seeking treatment for on the telehealth platform, associated health conditions. And as I mentioned, all this was personally identifiable, so tied to things like mobile ad IDs, email addresses, phone numbers that made it very, very easy to re-identify people with this information. And what we alleged was not only what was GoodRx sharing this information, but in fact, once it was shared with Facebook, the information was being re-identified. People were being matched to their medical information, and they were receiving targeted ads, for example, on Facebook and Instagram, through the use of Facebook's advertising platform. So a lot of problematic practices we alleged in our complaint. The first was deception. We alleged that GoodRx lied to consumers. There were explicit statements in its privacy policy saying that GoodRx never shared this type of sensitive information with third parties and advertisers, when in fact they were. So our complaint had about 5 different deception counts. We also alleged that some of these practices were unfair. Again, going back to our prohibition on unfair and deceptive business practices. And there specifically, we pointed out the fact that what we alleged was that GoodRx, not only was it lying to consumers, so its disclosures were off, but it actually had no privacy compliance policies in place at the company to actually make sure that information was being handled appropriately. So we allege that failure was an unfair business practice, especially for a company like GoodRx that is in the business of handling really sensitive health information. And finally, we allege that GoodRx's unauthorized disclosures were a violation of the health breach notification rule. And as Justin mentioned a moment ago, this is a rule that we enforce that requires companies that handle sensitive, personally identifiable health information to notify consumers, the FTC, and the media when there has been any kind of unauthorized disclosure of health information. That was the case here. And so we used our power. We enforced that rule for the first time and obtained $1.5 million in civil penalties. Again, this is the first time we've ever used this rule. So that's a little bit about the FTC's action against GoodRx.
Well, I mean, there's a lot to cover and a lot to talk about there, Ronnie. But then the FTC followed that up. I don't know if it was the same you or the same division with another important case. Just a month later, this one involving BetterHelp. And would you mind giving us a little bit of detail there? And again, on both of these, you're talking about practices involving sharing of data that are ad tech, kind of sharing that are widely used in the healthcare industry and outside, which is one of the notable things. But would you mind talking a little bit about the FTC action and BetterHelp?
Yeah, sure. So you're right. We brought a case against the online therapy platform BetterHelp, which many people may know. I believe they advertise all the time on podcasts. So very similar allegations, right? BetterHelp was using and integrating automated tracking tools from Facebook, Snap, Pinterest, Criteo, integrating them into the app and the website, just like in GoodRx, tracking health information and sending these over to the third parties. I believe in this case, the information that was being collected was responses to an intake questionnaire where consumers were turning over really sensitive information about their mental health. And again, BetterHelp was telling consumers that this information was being kept private and that it wouldn't be shared with the likes of Facebook, Criteo, Snap, and Pinterest. But in fact, what we allege was that it was. Again, similar to GoodRx, we allege that these were deceptive practices. And then we also allege that, just like GoodRx, BetterHelp failed to have any policies, programs, compliance protocols in place at the company to actually make sure that people's privacy was being respected, that the information was being handled appropriately. And we allege that failure, again, was an unfair business practice. And in that case, I'll just stop there.
And do you mind talking a little bit about, these were settlements. So what was the relief and the kind of penalties that came about?
Yeah, sure. So as part of these 2 settlements, the FTC obtained pretty groundbreaking and in some cases novel relief. So for example, in the GoodRx case, as part of the order that we agreed to with the company is actually banned from sharing health-related information for advertising ever again. In the case of sharing health information for any non-advertising purposes, the company is required to get affirmative express consent from consumers going forward. And the order lays out in great detail the ways in which the company has to do this. For example, it has to have clear and conspicuous disclosures and can't use any dark pattern practices that might subvert consumer choice. It also has to request the deletion of the data it illegally shared with companies like Facebook and Google. There's also a requirement that it mandate an internal privacy program, which is subject to ongoing audits by an independent third-party assessor. And the order also imposes data retention limits. So it requires GoodRx to actually have a policy as to how long it retains data, to actually publish that policy publicly, and tell consumers how it uses the information it collects about them. So that's a little bit about the GoodRx settlement. On top of that, as I mentioned, the BetterHelp settlement, we got very similar relief. But in addition to that, the FTC obtained $7.8 million in redress funds, which will go back to consumers as partial refunds. And this was the first commission action ever where we've obtained consumer redress in a health privacy case. So that was a big deal. And BetterHelp also, again, has a ban on sharing. In particular, the BetterHelp case also included a ban on sharing personal information for retargeting, and requires that the company get affirmative express consent to share personal information with third parties for any other purpose. So we were really excited about these settlements, and we think this really sends a strong message to the digital health industry and marketplace, what the consequences can be if you mishandle consumer data.
And, I know you covered this a fair amount in the introduction to both of these, and we're going to come next to HHS here in a moment, Lisa. But for folks watching, can you kind of talk through the key takeaways, Ronnie, from these two settlements, if you don't mind?
Sure. So there are a lot, depending on who you talk to and who you ask, but I'll highlight some of the takeaways that I think are the most important about these couple settlements. First, I think you're going to see that the FTC is going to continue to be the cop on the beat, especially in this area of direct to consumer health apps and services that are not covered by HIPAA. These cases really send a strong message that the FTC is watching and is going to be vigorously enforcing the law where companies are engaging in data misuse. Second, health information that's a broad concept. And I think the GoodRx and BetterHelp cases really help illustrate that concept. So your health information is not just information you provide to your doctor at the doctor's office, right? Your inputs into apps like GoodRx, BetterHelp can be health information, not covered by HIPAA. In BetterHelp specifically, we allege that sharing of email addresses was health information. And how is an email address health information? Well, for example, your email address being tied to your use of a mental health service like BetterHelp, when you take those two pieces of information together, can become health information. So I think the takeaway there is that personal information can become health information, and context really matters. Go ahead, Justin.
Well, I mean, again, I know there's limits on how you can talk about this, Ronnie, because you're on the enforcement side, believe me. But that's a really important concept, which is context matters.
That's right.
And context matters in the sense that something that many marketers, I don't mean to single out marketers, but business folks often think of certain identifiers or things that are arguably not direct identifiers of a person, a probabilistic ID, as California is using it, as not necessarily sensitive health information. And if that sensitive health information, if the ID was collected in a context that betrays something sensitive about the person, I think marketers have to be a lot more sensitive about it. Do you have a way that the community can think about what is sensitive health information? Like, how do you think about the broadness of that concept, if you're able to talk about that?
Yeah, I guess there's no one right answer on this, but, again, realizing that health information is not just information covered by HIPAA that's you tell to your doctor. So another example is location information, right? If an app or service tracks you at places like an abortion clinic or a reproductive health center and has other personally identifiable information about you, well, they can make the inference or assumption that you're at the abortion clinic because you might be pregnant or seeking an abortion. So geolocation information is another area where sort of context matters, and combined with the right identifiers can become health information. And we actually recently had a lawsuit against a data broker named Kachava for practices relating to the collection and sale of geolocation information.
Yeah, this is a really important developing area. And again, I know it's developing, and by definition, it's hard to define some of these things because it's defined by the context. And if I may shift, Lisa, over to you for a moment. I mentioned there was in my view, a very important bulletin that came out from Health and Human Services in December around the sharing of data for ad purposes. I think it's worth folks reading it, and I know it kind of speaks for itself. But would you mind talking a little bit about how the HIPAA privacy rule applies to online tracking and what kinds of protected health information may be involved in that context?
Sure. So just to provide a little bit more information about the bulletin that Justin mentioned, on December 1st, OCR issued, it's called a Bulletin on Requirements under HIPAA for Online Tracking Technologies to Protect the Privacy and Security of Health Information. So if you're Googling, that's the nice and short title to it, of course. Sorry, there's no acronym for it as the government, so you'd think there would be. But for those of you who aren't familiar with HIPAA and the HIPAA rules, just to give a little context, the privacy rule and the HIPAA rules generally are limited to in their application to covered entities and their business associates. So what are we talking about? We often refer to them as regulated entities. So who are we talking about? We're talking about health plans, we're talking about healthcare clearinghouses, and we're talking about most healthcare providers, but not all. And generally, the good rule of thumb to figure out whether a healthcare provider is a covered entity is whether or not they're billing insurance. They may not be billing your insurance, if they don't take your insurance, for example, but as long as they are billing somebody's insurance company, then generally they're going to be a covered entity. And then a business associate is a person, and person actually has a technical definition under HIPAA. So it's not just what we generally think of as a person, but it's also a company, an organization, or entity too that creates, receives, maintains, or transmits protected health information for or on behalf of a covered entity, or that provides certain services to or for a covered entity that involve access to PHI, or protected health information. And going back to what we were just talking about in terms of sensitive health information, protected health information is a very clearly defined term under HIPAA, and it's individually identifiable health information, which includes demographic information. So going back to discussion that you're just having about names, email addresses, all of that is once it's in the hands of a covered entity or their business associate that is PHI under HIPAA, then so that PHI, that it's transmitted or maintained in any form by a covered entity or their business associate within certain limitations. Excuse me, with certain limited exceptions. And under the privacy rule, covered entities and their business associates are prohibited from using or disclosing. So that's, again, technical terms. We don't use the term sharing. They're prohibited from using or disclosing PHI, except where it's explicitly permitted or required by the rule. And so the online tracking guidance really goes through in detail how the privacy rule and online tracking technologies interact. And so it really defines what is an online tracking technology. And so I think it becomes pretty clear the audience here, I think, probably knows what it is, but we define it in the guidance. And so it's online tracking, whether it's on websites or on mobile apps. And it's a script or code on a website or a mobile app that's used to gather information about users as they interact with the website and the mobile app. After that information is collected by the technologies, it's then analyzed by the owners of the website or the mobile app or third parties to create insights about users' online activities. So talked about, common examples of this are Google Analytics or Metapixel. And they track a wide variety of information about website visitors or mobile app users, and they do it in a variety of different ways. And so, a lot of these technologies are not just, we just talked about, some of them are developed internally, but some of them are developed by third parties. And generally those that are developed by third parties, they send the information directly to that developer of that technology, and they may continue to track users and gather information about them even after they navigate away from the website. So they disclose a variety of information to the tracking technology vendors, where the technology is placed on the regulated entity's website or mobile app. And that information can include individually identifiable health information that the individual provides when they use those regulated entities, websites, or mobile apps. And so that's information that is regulated under HIPAA. And so when it's collected, it's generally going to be protected health information because it is collected by that regulated entity. Even if there's no existing, what we said in the guidance is, even if there's no existing relationship between the individual and the regulated entity, and even if the IHI, the individually identifiable health information, does not include specific treatment or billing information. And that's because when the regulated entity is collecting that information through their website or mobile app, the information is generally indicating that the individual has received or will receive healthcare services or benefits from the covered entity, and thus it relates to the individual's past, present, or future health or healthcare or payment for healthcare, which all goes back into those definitions under HIPAA. And so it's all, for example, last month was Colorectal Cancer Awareness Month, right? So tracking technology on a healthcare provider's website could let the tracking technology vendor know that I was looking at information about colonoscopies. That would provide that vendor with information about my present, past, future health or healthcare.
I mean, this is, again, first of all, that was a great summary of a lot of complicated, important principles under HIPAA. So Lisa, thank you for that. But you're getting a picture between the FTC's enforcement actions and HHS's guidance. And if you've seen some of our prior sessions with California Attorney General enforcement under the Sephora case, again, it comes to a general set of themes that I know you may or may not be able to comment on, but if you don't mind, I'll summarize it from my perspective. The sharing of data via these ad pixels and location data with third-party platforms, depending on the context, could reveal HIPAA-covered information or sensitive health information. And when you're sharing anything via pixel or location data, a company using that technology really should be analyzing it very, very carefully. And it's part of what California has been pushing out in a, not pushing, but talking about as technical matters, is that, for probably 20 years, data would have been shared via pixels or via third-party cookies, but there's often no notice in a meaningful way to a consumer that it's happening. And there's no obvious way to block it from happening before it actually happens. Often when you land on a website, the pixel fires before you even had a chance to see what the heck is happening, right? And so you've seen in Sephora, California has been talking about a data layer that protects the firing of the pixels, opt-outs using these touchless technologies like global privacy control and other means like this. But it seems to me it's all around the same general theory that people have to be given some fair understanding of where that data is going, that the context in which that data is collected could be highly sensitive to a person, and that if you don't give some ability for you to have a choice there, you might be breaching that person's, privacy in that way. And for me personally, it's hard to take that apart from the broader context of, I'll say, women's healthcare rights, in the sense that you might have investigations going on under state law in parts of the country about receiving certain healthcare, right? So it's a very important set of principles, but you're talking about data flows that are complicated in terms of exactly what happens on a mobile app or on a website, exactly what data is shared, whether it's, advertising pixel data or location data, and then with whom, like who is it that actually got that data for what purpose? And I think that's one of the major sets of takeaways. And on that, sort of basis, without having you agree or disagree with anything I just said, from your perspective and from the HHS perspective, how does the online tracking pose a risk to privacy and security of PHI, in this context, Lisa? And what steps do you think covered entities and business associates should be taking to kind of mitigate those risks?
I mean, I think, we understand online tracking technology can be helpful to regulated entities. It can provide them with, insights into what visitors to their website and users of their apps are interested in, and, how they can improve those websites and apps, and how they can better market their services and more. But the way it's done can raise privacy and security concerns. So that is, to obtain information, to obtain the insights from the vendors, regulated entities sometimes will allow vendors access to that PHI that is, again, highly sensitive information about individuals. So in so doing, they give the online tracking vendors access to not only that sensitive information, but also they give them the potential to combine it with other information the tracking technology vendor has obtained about the individual, giving the vendor or other, future purchasers of the information a lot of insights about the individuals. And so, I think, again, the guidance really, I think, provides a lot of examples. And I know it is a little long for people who have limited time, but it does provide a lot of examples of how regulated entities can take steps to mitigate the risks. And that includes, configuring user authenticated web pages that include tracking technologies to allow those technologies to only use and disclose PHI in compliance with the rule, and to ensure that electronic PHI or ePHI collected through the website is protected and secured in compliance with the security rule. Another step, another way that regulated entities can mitigate the risks are to identify where a tracking technology vendor is a business associate. That is, again, go back to that definition. So where the tracking technology is creating, receiving, maintaining, transmitting PHI on behalf of a regulated entity for a covered function, for example, healthcare operations, which is also a defined term under HIPAA, or provide certain services to or for a regulated entity that involve the disclosure of PHI. So where that's the case, regulated entities have to ensure that the disclosures are made to the vendors are permitted by the privacy rules. So not just any disclosure can be made. And they do need to enter into a business associate agreement or a BAA with those tracking technology vendors to ensure that PHI is protected in accordance with the rules. We do note that some of the tracking technology vendors are not interested in signing business associate agreements. And so covered entities do need to think carefully about entering into arrangements with them. And then where you're dealing with unauthenticated pages, so that's web pages that don't require users to log in, determine whether or not the tracking technologies on those pages would have access to PHI. If they do, then the HIPAA rules would apply to the regulated entities' use of technologies and disclosures to technology. So one of the examples we use in the guidance is a login page of a regulated entity's patient portal. The login page itself is generally unauthenticated because the individual hasn't provided credentials to be able to navigate to that page. However, if that individual enters credential information on that login page, then that information is now PHI. And so any tracking technologies on the portal login page collect PHI, and that information needs to be protected under the HIPAA rules. And then lastly, I'll talk one step in terms of mobile apps, where the mobile app is offered to individuals by a regulated entity. So the information is, we sort of divide apps into two different categories in the HIPAA rules. We have those that are offered by a regulated entity, so by a covered entity, their business associate, and all other apps. The HIPAA rules apply to the ones that are offered by the business associate or the covered entity. So it can be, a company can have two different apps, one that's offered through regulated entities and one that isn't. And so even though it's the same company, one app is going to be falling within the HIPAA rules and one is not. And so where it's offered through the regulated entity, the information that the app is collecting from the user, as well as any information provided by the user's device. So we go back to any geolocation data, fingerprints, Face ID, all of those types of things. It's now associated with the individual. It's collected by the regulated entity. And so now it's PHI. And so thus the regulated entity, when using tracking technology through a mobile app, must comply with the HIPAA rules for any PHI that the app is using or disclosing, including any subsequent disclosures to the app vendor. So I think those are just some of the.
Yeah, this is some really, really important guidance, Lisa. And I know we're getting down to just 5-10 minutes. I want to make sure, as usual, we give the folks here a chance to ask any questions. So if you have questions for either Ronnie or Lisa, please feel free to raise your hand and we can go through them on either side. And if not, I'm gonna keep going on the enforcement side. Lisa, from HHS, can you talk about how enforcement actually happens for these? Like, who enforces and how does it happen?
Sure. So OCR also, not only do we develop the policy and issue it, but we do also enforce those rules. And we conduct that in compliance with the, in accordance with the enforcement rule, which is available for everyone to take a look at. So we generally open investigations into potential violations in a couple of different ways. One is as a result of complaints that are filed with OCR. And we have a complaint form that's available online if anybody is interested in taking a look at that or filing a complaint because you think the HIPAA rules have been violated in a case that you've been involved in a situation. Or the other way an investigation can be opened is that we can initiate an investigation ourselves. So for instance, based on a breach report or a media story, what we find during the investigation actually determines the next step. So generally, our first step is going to be providing technical assistance to the regulated entity. And then we consider additional actions when technical assistance is insufficient to resolve the issue, such as when a regulated entity is unresponsive or fails to comply voluntarily or to take corrective action. We do have the authority and we will pursue civil monetary penalties or CMPs for unaddressed violations when appropriate. And that's true whether we're dealing with a violation stemming from the use of online tracking technologies or failure to comply with the individual's right of access, which is another big initiative that we've had. But I think it's one thing that's really important for covered entities and business associates to consider is, the cost associated with HIPAA rules non-compliance is not solely monetary. Yes, in the case of a settlement, there is a monetary penalty. There's also usually a requirement for a corrective action plan, which involves a period of monitoring by OCR, as well as a period of working with OCR to ensure that that the regulated entity's policies and procedures are compliant. But even beyond that, there's that loss of public trust. And I think that's really what regulated entities need to sort of keep in mind when they're doing this. Is it really? It's not really about the financial cost. It's about what does it do to the public's trust in your ability to keep their sensitive information, in our case, PHI, private.
And that's a perfect transition. Amy, did you have a question? Yeah, please go ahead. I'll repeat it back so folks can hear. Amy, I'm going to paraphrase. I hope I have this right. That the BetterHelp had
was it BetterHelp or GoodRx or both? Okay, I'm happy to talk about both.
Yeah, if I could just summarize the question, were BetterHelp and RX focused on the transparency issue? In other words, consumers weren't given notice and real upfront chance to make a choice, or was it the fact that the data was collected and shared that caused the violation. I didn't do it as elegantly as Amy did, but
totally. I appreciate your question, by the way. So certainly transparency is a very big part of it, right? FTC 101, do not deceive consumers, tell consumers the truth about what you're doing with their data. So that cannot be understated, or cannot be overstated, rather. It is a big, important part of it. But if you read the GoodRx and BetterHelp complaints in terms of what the FTC alleges, there are a lot of practices with which we took issue and that we allege were deceptive or unfair. So just to give you an example, the fact that GoodRx and BetterHelp had no internal privacy compliance programs. It was kind of the wild, wild west. So while that in and of itself was not an explicit representation to consumers, we consider that to be an unfair practice. And again, these are companies, multi-billion-dollar companies. Some of them are publicly traded that just had no privacy compliance going on internally. The FTC complaint also alleged that GoodRx, for example, was sharing data with third parties that were not service providers. So companies like Facebook that could and did use the data for their own internal research and development purposes, for ad optimization. So not having, agreements in place, like service provider agreements, like BAA agreements, like Lisa just mentioned a moment ago, that limit how these third parties can use, disclose, exploit the data. Ideally, you want to have those service provider agreements in place to make sure that the data, when shared with the vendor, is only used for that specific purpose. I think people mentioned that on the other panel as something that's very obvious, but in the case of GoodRx, that wasn't even happening. And finally, don't use the data. I think a message that these cases send is do not use sensitive health information that's personally identifiable to advertise. That's a practice that's very harmful to consumers. And it's also worth pointing out that platforms like Facebook and Google don't even permit that to occur on that platform. Somehow it was. But even the platforms don't condone this type of activity. So I'll stop there. I see we have another question.
Can I pass this out to folks to just ask the question so you can be heard?
So I'll try to make this short. I think the FTC's decisions in BetterHelp and GoodRx are fascinating on a lot of levels, partly to see the breadth of the unfairness language that's used, but the deception seems super clear cut. So my question actually, I think for both of you is, a lot of the facts in those two cases and a lot of what is coming out in the guidance on HHS doesn't specifically talk about lookalike modeling, which I think is widespread across the entire health industry, both for covered providers and for non-covered providers. I'm curious if you have any way that you could help us think about what companies doing lookalike modeling in the health space should be doing, both for transparency purposes and for choice for the consumer.
Yeah, so first of all, the BetterHelp case, actually, I believe it did deal with lookalike audience modeling. I believe when the data was being shared, in part, the information was being used to create lookalike audiences. I don't believe we've issued any specific guidance on this, but again, getting consent, making sure that how the data is being used once it's being shared with these third-party platforms to create lookalike audiences. Is the information personally identifiable? When you share the information, for example, with Facebook to create a lookalike model audience, however you call it, Facebook is still able to, even if they're creating an audience of other people, Facebook is still able to exploit and use the data that it created about the first group of individuals. So I think there's a lot of issues. It's kind of hard to talk about in like a 30-second sort of answer to a question at a conference. I don't think we've issued any guidance on this, but I think companies need to think really carefully about how they're sharing data, how they're using it to advertise, whether or not they're integrating these plug and play ad pixels and SDKs into their product. And again, context matters, right? At the end of the day, is the information personally identifiable, and can it be used to infer information about an individual's health? If the answer is yes, then you really need to think clearly about what your obligations are under the FTC Act, the Health Breach Notification Rule, and if you're covered by HIPAA, HHS.
Again, say from the consumer's site that's collecting and this data in a pixel, the sensitive health information in a pixel and using it for ad purposes, arguably. And that hypothetical, what is is there a concept of the kind of notification and permission that is required before that can occur? Is it because most of you have to say it explicitly and get consent before an ad can be served, or is that one of those things that is still being investigated? I'm focused on this concept of you collect the data and share it via pixel for advertising. That's not permitted. It sounded like in the sensitive health information context, absent permission, notice and permission. Is that the way the FTC is thinking about it?
Well, we have issued guidance saying that when you are sharing sensitive health information for certain purposes, you should be getting affirmative express consent, sort of just in time affirmative express consent. So at the time of collection or, what have you, from consumers. But, there is this idea, I think, following these cases that, that might not be enough. And we might actually need bright line rules that prohibit these kinds of really harmful practices to consumers altogether. Coming from the FTC, sharing people's health information for advertising is a really bad practice. There is a lot of harm that's, could down the line result to consumers. You have a whole ecosystem of data brokers that buy, share, and sell this and exploit this information, and can make all kinds of inferences and discriminatory decisions about individuals. So it's a really harmful practice in general. And so there's a question about whether or not even affirmative express consent is enough when you're dealing with a really harmful practice to consumers. I see we have another question.
Thank you for coming today. Speaking not as a lawyer, but as the mother of a child who has pretty serious asthma. I have throughout the years participated in different programs where I've signed up for cards like GoodRx or whatever. I've allowed his information to be used in different ways, so I didn't have to pay $300 a month for the particular asthma medication I needed. I certainly understand your point about the potential misuse of information, particularly location information. But as a consumer, what if I want to give my information to a company, say a GoodRx competitor? There's no way for those smaller companies to compete because it sounds like you can't advertise to people. Because there are plenty of ways where you could say to Facebook, and this is actually now happening with very, very large retailers. You could go to a very large retailer as an advertiser and say, here's my ad, show it to, soccer moms between the ages of 20 and 50. And they could go do that, and then they would have all that information, and they just basically use that to become bigger and bigger. And all of the smaller competitive companies can't possibly advertise to those people. So I think there is a way with Facebook, for instance, to say to Facebook, okay, hey, as your role, in this role, I want to hit these particular people. I want you to serve my ad to these people. And then Facebook doesn't give back any of the information. Or to say to somebody like Facebook, hey, I'm going to share data with you. You can't use this particular data, the data I gave you, for anything else, but I need you to find people who look like this. And then Facebook can say, okay, well, we ran those numbers up against our numbers, and it looks like it's not soccer moms, it's rugged dads. And this is how you should try to advertise to these people because you're a small company and you're trying to reach this audience. Facebook doesn't use that information for other things. The company itself doesn't really care who I am. Like, this is the whole reason we set this stuff up. And so I'm just wondering, is the end point really, we're just going to allow these large retailers to be the new ad platforms and put all of these smaller companies out of business? Because there just isn't a way to advertise anymore, to get your name out there if you're a small company.
Yeah, thank you for your comment. I'm aware we're almost at time. What organization are you with, by the way?
I'm with the firm now.
Oh, okay. Yeah. Oh, great. Okay. Yeah. So I think your question probably requires a lot more time than we have, but I will say first on the question of using information to advertise, if it can be done in a privacy protective way, I'm not as someone here from the FTC, I'm not here to prescribe how that can be done. But I will say hearing from consumers after the announcement of the GoodRx and BetterHelp cases, consumers are horrified that their information is being shared to advertise, and most people think it's egregious. So there may be a subset of individuals who might find that to be an efficient model. I don't know. But yeah, I think, our priority is making sure that it's being disclosed, and that companies have the right policies to protect consumers and their data from all of the harm that can result.
Sites because their information is being used for. Once they realize they can't access all these sites or these particular sites or companies are going out of business, that's when it gets very.
Yeah, and I'll just add, companies can still advertise. GoodRx is still going to be in the business of advertising all the time. I still get their advertisements. They have TV ads, they have online advertisements. They just can't use your sensitive health information. They can't know that you have a certain health condition in order to do that. So some might find that inefficient. I think that's privacy protective.
I do want to make sure we get, we did start a few minutes late, and I know you all are on a schedule, so I don't want to go too far over. There was one question, and then maybe we'll take it. Ronnie, can you talk from the FTC's perspective about what can we expect from the FTC in terms of future enforcement in the health data space? And obviously the context that you gave here is really important. The idea that if sensitive health information is being used to surface an ad, generally the FTC is looking for explicit consent, and there may be certain circumstances where it may not be done. Can't be defined here, of course, but this is the kind of approach. How is the FTC looking at enforcing, in the health data space this year?
Yeah, so can't talk too much about any ongoing investigations we may have. I can talk in broad strokes. First, I think you're going to continue to see the FTC being really aggressive and bringing enforcement action similar to GoodRx and BetterHelp. Second, I think this concept of what is health information is going to continue to be front of mind. Again, when you have things like location information being used to infer information about your health. In the case of BetterHelp, your email address associated with your use of BetterHelp was health information. I think you're also going to see, and some of you may have already heard, we're in the process of determining whether or not a bright line commercial surveillance rule, in the absence of legislation from Congress, that prescribes how companies can and cannot use people's data, whether or not that's needed. So we're currently in the initial stages of reviewing comments on what that would look like, what sort of practices would be permitted and which would not be permitted. But if this does come to pass, what you'll see is clear guidance to companies about how they can and cannot use people's data. And if they violate that rule, they would be subject to civil penalties. And again, that's in the absence of Congress acting to pass the ADPPA. And finally, we're going to continue to do outreach, educate consumers and the public. Check out our website. We have something that we worked on with HHS. It was a mobile health app tool that allows app publishers to kind of go through different steps, answer some questions, and figure out which laws might apply to their app or their business. So that's a little bit of a summary, but happy to chat with others after this.
Okay, Lisa, do you want to get a last word in here? I know we're at time, but anything else you want to add from the HHS perspective?
Well, I certainly can't comment on anything that we're working on in the enforcement area at this time. But I think, I think the online tracking bulletin is out there. And so, I think it's really important that companies take a look at that and make sure they're in compliance.
Just trying to ask a quick question. In the ad world for a while, the NAI has this code, and typically like AIDS and cancer is on one end, and like asthma and heart disease would be on the other. As everybody's got asthma, everybody's got heart disease, so those are sort of less concerning. I know not from HIPAA, but just sort of from the FTC side. Is all health information potentially as concerning, or are the more common ones sort of less of a problem?
Yeah, I know we're at time, but I'll try answering that real quick. I mean, I would say no. I think when you start drawing lines, you get into dangerous territory. It becomes a slippery slope. And what I think health information in and of itself is really sensitive. And again, it's one of those things, once it's out there, the bell cannot be unrung, right? It's not like your credit card information that can be replaced. Once it's out there, and people can use it and exploit it in ways that you don't intend. So
I do. I just want to say on behalf of all of us, and these are really important educational sessions for Ronnie and Lisa, for the community, for folks just trying to make sure they're doing the right thing. And the BetterHelp and the GoodRx cases are very important in my view, in the sense of any companies that are collecting and sharing sensitive health information with third parties for advertising, they're on notice. And I mean, in my view, hundreds of thousands, if not millions of companies are doing this kind of ad sharing using very commonly used pixels, tags, scripts, and cookies. And they really do need to pay attention to this right now, because you have to analyze not only what data is going, but the context in which that signal was sent. It's an important judgment. I can say for both of you, thank you very much for coming to share your insights with the community. I'm sure there are going to be folks who have questions afterwards. I could see people raising their hands, and I guarantee you this session will be widely watched as part of the spokes community. And I do want to thank you for all of your work in this area. So
it's been a pleasure. Thank you, Justin.
Thank you all. We're going to take another break for 5 minutes, and then we have a terrific session on enforcement of data privacy and data protection. I'm sorry, I messed that up. Of course, in Europe, it's data protection. Anna in the back is going to send me daggers for using the wrong term. Data protection and privacy enforcement in Europe. We'll have that shortly. And Ronnie and Lisa, thanks again.